So good morning in Japan and good evening in the United States. I'm Jason Murata, a partner at the firm of Axon, Veltrop and Harkrider. Together with Todd Baker, I am a co-chair of the AIPLA-IP Practice in Japan Committee. It is my pleasure to welcome you to the joint meeting of the Japan Intellectual Property Association and AIPLA's IP Practice in Japan Committee. We are, of course, very disappointed that COVID has prevented us from meeting in person both last year and this year. However, thanks to online technology, we are very fortunate to have the opportunity today to continue the long-standing relationship between our organizations and to again exchange very important information relating to IP practice in our respective countries. I would like to take a moment to thank the sponsors of AIPLA's IP Practice in Japan Committee. They are Axon, Veltrop and Harkrider, Finnegan, Henderson, Gowling, WLG, Greenbloom and Steen, the Honigman firm, Kirkland and Ellis, Nabi Martins, the Oblong firm, Osha, Bergman, Watanabe and Burton, Prince Pines, Shook, Hardy and Bacon, Smart and Bigger, and Baker and Brackett. Thanks to these firms for really helping this committee do the work that it does. Before we get started, I'd like to remind everybody about a few ground rules. The educational program today is being recorded. The networking session that follows will not be recorded. To avoid stray noises, please keep both your video and microphone muted during the presentations if you are not one of the speakers. If you have any questions, please enter them into the chat box. If the speakers are able to do so, they will pick up the questions in the chat box. With that, we will have some opening remarks from each of the participating organizations. First, I'd like to invite Mr. Joe Ray, President of AIPLA, to offer some opening remarks.
Thank you, Jason. It's great to see everybody, and it's great to see so many leaders from both organizations. And I only want to echo what Jason said. I regret that we can't see each other in person, but we welcome this opportunity to exchange ideas. And I'm so happy to see so many leaders from our American delegation. I even see former President Mel Garner. I see a partner of mine, Irfan Latif, and I see many other leaders and board members of the AIPLA. I see Bob Stoll. I just want to welcome everybody, and I'm very happy that you're all here participating. Thank you.
Thank you, Joe. I would now like to invite a representative from JIPA to provide their opening remarks.
すみません。山中理事にご挨拶お願いしてよろしいですか。よろしくお願いします。
Okay, can you hear my voice?
Yes, we can hear your voice.
Okay. Thank you for our presentation. Greeting. So I'm Akitoshi Yamanaka, Director of IP Division of Denso Corporation, an automobile parts company, and attending this meeting as the Managing Director of JIPA in charge of this committee. So I'm very grateful that JIPA and AIPLA regular meeting will be held again this year, even it is such a Teams meeting. While various activities have been suspended due to COVID-19. So I'd like to thank you that the member of AIPLA and JIPA for their various efforts for preparing this meeting. So also I thank AIPLA members for sending the material in advance. So Article 101 and 112 will be more important concept in future when preparing the AI or software-related invention. So we believe that today's discussion will be meaningful for both parties. Thank you very much, and enjoy myself. Thank you.
Thank you, Yamanaka-san. So we will now begin the formal portion of our program. We are pleased to have Ms. Daphne Laneson from AIPLA provide an update regarding Section 112F means plus function claims.
Thank you, Jason. Oh, my apologies. Sumimasen. Ohayo gozaimasu. Thank you very much for joining us today. This presentation was originally prepared by Libby DeMarco, who unfortunately was not able to make today's meeting. So I am presenting these slides on her behalf. So the topic is means plus function claims. And we are going to review what is a means plus function claim, the scope of means plus function claims, how to interpret a means plus function term, the significance of means plus function claims during litigation, and some practice tips for you. So let us start with understanding what is a means plus function term. This is when we have functional claim language that describes an apparatus in terms of what the apparatus does rather than what it is. And means plus function claims do not always use the word means. So some examples are claims that do include means for doing something. But the second example, a control module for receiving, could be construed as a means plus function term, or a control assembly configured to do something could be construed as a means plus function term. So the difficulty with means plus function claims comes in because of 112F. So if you have a means plus function claim term, the claim shall be construed to cover the corresponding structure, material, or acts described in the specification. So a means plus function claim is only valid if the specification contains support for the structures that define the means. If not, your claim may be indefinite. So when we are discussing means plus function claiming, we have a two-step analysis that we apply. So the first question is whether the claim term is a means plus function term subject to the requirements of 112F. If it is, so if the answer is yes, the question then is what is the corresponding structure recited in the specification? Now these two questions are related, but they are treated distinctly. So let's look at the first part. Is the claim term subject to 112F? So if your claim uses the term means, there is a rebuttable presumption or an assumption that 112F will apply. But if your claim lacks the word means, there is a rebuttable presumption that 112F does not apply, or an assumption that it does not apply. Now, the Williamson decision from 2015 lowered the standard for rebutting the presumption that 112F does not apply. Previously, there was a strong presumption that a term or a claim without the word means is not subject to 112F. So the question is whether the words of the claim would be understood by a person of ordinary skill in the art to have a sufficiently definite meaning as the name for structure. So is it clear? Is it definite? The presumption can be overcome by a potential infringer, for instance, if the claim term fails to recite sufficiently definite structure, so it's very functional, or recites function without reciting sufficient structure to perform that function. So, if you have a claim that does not use the word means, the question or the test focuses on whether the claim recites sufficient structure. So if you have a claim reciting a function, but goes on to elaborate sufficient structure, material, or acts within the claim itself to perform entirely that recited function, then the claim is not in means plus function format. Now, this is a very context-specific inquiry. In order to understand whether a claim term is subject to 112F, we need to look at the surrounding claim language. What else does the claim say? We need to look at the specification. How does the description describe the term? We need to look at the prosecution history. What did the applicant say during prosecution about the term? And we need to consider extrinsic evidence. So what do the experts, what does the skilled person in the art think about that particular term? In the Samsung case mentioned on this slide, the Federal Circuit found the term digital processing unit was not a means plus function term because of the surrounding claim language, other dependent claims, and expert testimony. So over the years, claim drafting has changed. This slide is now a few years old. It's from 2014, but Professor Crouch considered functional claim language in issued patents from the mid-1970s until 2014. And as we see on this slide, the blue line represents independent claims, including means language. And as we can see, that has significantly declined over this period of time. We also saw an increase in language in claims that had for doing something. So for receiving, for example, that language increased but seemed to plateau. And an increase, the red line shows an increase in independent claims containing language such as configured to or configured for. So claims that are trying to provide greater structure to avoid 112F. Now, often claims will include nonce words or generic words that are commonly substituted for means language. But you should be careful because often this language is nevertheless construed to be means plus function type terms that are subject to 112F. So language to be careful in using is words like mechanism, module, device, unit, component, element, member, or machine. But what about processor? The term processor is usually not subject to 112F, but as noted in this case, it can be if the claim term is really just to a generic processor. So in the beginning, I mentioned that means plus function claiming required two steps, and the second step was if your claim term is considered means plus function language, so it's subject to 112F. The next question is there corresponding structure recited in the specification? So let's say you have a term where there are multiple claimed functions. Well, the difficulty with that is that you would need to disclose adequate corresponding structure to perform all of those claimed functions. Now, software is something of a special case. So if you have a microprocessor programmed to do something, the structure of a microprocessor in this case would be limited by the disclosed algorithm. Now, there is an exception, the CATS exception, where if you have terms such as processing, receiving, or storing that can be achieved by any general purpose computer without special programming, then these do not require disclosure of more structure than the general purpose processor performing these functions. So the significance of 112F is that in a litigation, you may then end up having an indefinite claim. So if the specification does not provide sufficient structure, the term may be considered indefinite and the claim invalid. Another problem arises with non-infringement. If the term is a means plus function term and subject to 112F, the claim term is going to be limited in its construction to the structure. And so it's possible that an accused infringer can avoid the claim. So 112F can be quite limiting. So one practice tip is to consider having processor claims. So this will make sense if it's unquestionable that the recited function can be implemented in a processor. You can also consider other structural type language. So for example, a circuit or a control circuit. So in the MIT case mentioned here, if you had a term like circuitry, the court said that that itself connoted structure. So that provided structure to the term. You can consider using method claims because these will often give you broader coverage. But the difficulty with a method claim is that it may be limited in terms of its enforcement to only the end user or showing indirect infringement, which may be more difficult to establish. So during patent prosecution, you have to be careful about the types of terms you use. And if you are going to use processor, make sure you provide particular context within the claim to make it specific. And you will want to include language within the claim to show how the processor operates and interacts with other parts of the invention claimed. So it clearly is providing a structural component to the claim language. So when we have an office action with a 112F issue, there are a number of ways that you can consider deciding on how to approach the problem. One option is to present arguments to the examiner that show the existing claim limitation provides you with sufficient structure. In this case, you would want to refer to intrinsic evidence. So you would want to point to other language within the claim and also to the specification. You could amend the claim to recite a definite structure or material that entirely performs that function. Now, if the 112F issue is not relevant to or will not prevent patent grant, you should note a disagreement on the record that 112F would apply. You want to leave open the possibility during litigation that the claim is not limited by 112F. So you want to make clear on the record your disagreement with the examiner's interpretation. And if you are doing this, then you will probably want to point to reasons within the specification to support that there is this structural feature. So there are a number of ways that you can address these issues if they arise during prosecution. And I think with that, perhaps we can now have a discussion about means plus function claiming. And I see I'm a little early, Jason.
We appreciate that. If anyone has any questions, please feel free to type them into the chat window or to unmute your microphone and ask Daphne directly.
Here is a very somewhat of a technical question, and perhaps if we have any people with practices within the computer arts, they might want to weigh in. But the question is, does the term processor include an analog circuit if an examiner admits the processor is not a means plus function term? Some methods can be done by a simple circuit, such as an analog circuit. So, full disclosure, I am a chemist. So I would appreciate if others on the call may be able to answer this somewhat more technical question with respect to processor and analog circuitry. And I don't know if Don Studebaker is on, if maybe he wants to jump in, or Chris Fields. And I know I'm pointing to people specifically, but
I'm a mechanical guy, so I don't deal with processors much. So I'd have to defer as well.
I'll go out on a limb and say that they're the same, that it wouldn't matter if the processor's digital or analog. I'm actually from the day when there was only analog, so I remember that.
Thank you, Mel.
Hi guys, it's Neil Henderson here. There was actually a specific case that covered this question. And to be honest, I don't remember which way it went down, but I will try and find that case and maybe post it later on.
Daphne, this is Todd Baker. I have a question for you. Do you see 112F issues in the life sciences types of cases?
Less so, although Tom Irving, actually one of Patrick's partners, wrote a fairly detailed paper on this particular point, where he thought that means plus function language could actually be helpful when you have a life sciences invention to try and use functional language, but really be specific to structures. So there could be, I guess there could be reasons why you might want to use it within the life sciences context, or rely on 112F within the life sciences context, perhaps quite different and distinct from situations that arise in the computer and mechanical arts. But I think it is a less common issue.
Thank you.
Oh, Jason, you're on mute.
Thank you, Daphne. That was a great presentation. Appreciate you jumping in to help out. Our next presenter is Moriyama Satoshi from JIPA. His presentation is entitled Case Study Regarding AI-Related Inventions Patentability in the US. Mr. Moriyama.
表示でフルスクリーンモードでやるといいじゃないですかね。
すいません。Can you hear me?
Yes, we can hear you.
Okay. And now I share my slides, but it's not showing in Teams application. Can you see my slides?
We can see them, yes.
Yeah, really? Okay. So I'll start. Okay.
全画面表示できますかね。表示の全画面という形で。
全画面、はい。お待ちください。
表示のタブの上の表示というところのタブで、そこでフルスクリーンモードで下の方に、
動かないかな。OK。ちょっとおかしい。制御がおかしいの。すみません。このまま進みます。I'm sorry for captivating you. Okay, let's start about my presentation. Okay, good evening and good morning, everyone. This is Satoshi Moriyama from Japan Intellectual Property Association, generally called JIPA. I also belong to Japanese electronic print maker named Seiko Epson. I would like to make a presentation regarding AI-related inventions patentability in US in this session. Okay, this is topics of this session. Firstly, I will make a presentation regarding topic 1, patent eligibility. Secondly, I will make a presentation regarding topic 2, non-obviousness. I have also introduced this slide to USPTO last December. At that time, we have 30 minutes, so today I skip some slides about response to the request for comments, and I will omitting detailed explanation of invention 101 case studies. Basically, I will focus on our tips in the patent prosecution in applicant's view based on case study of some patents. After presentation, we will move on Q&A session. If you have any question, please ask me after presentation. So let's move on topic 1, patent eligibility. I will cut detail of response to the request for comments today, but USPTO explain about Alice smile test that is common standard for 101 rejection. We can understand the USPTO's basic standpoint on patent eligibility from the report. However, our concern is actual determination of patent eligibility regarding AI-related inventions in the real patent examination. Okay. As you know, the FINIA is patent eligibility guideline revised in 2019. We will summarize. We will analyze some tests regarding from 1 and 2 following slides. Okay. I will explain case 1. As I said, I will omit detailed explanation of invention about 101 case. But the invention led to monitoring the operation of machines. In this case, tips in the patent prosecution is describe AI-related elements in claims as written in red letter in strides. In this case, the applicant amends and adds AI-related elements just like a neural network logic decision tree. Okay, next. Case 2. In this case, tips in patent prosecution is describe technical details related to AI-related elements in claims. The invention relates to graphical user interface. Case 2, tips of case 2 is similar to case 1, but case 1 just describe AI-related elements like neural network. On the other hand, case 2 describe technical details as written in red and purple letter shown in the slides. In the appeal brief, the applicant emphasized the claim set recites technical details related to presenting a decision tree and in response to user input, updating the decision tree. And then the examiner was persuaded. In next, case 3, tips in the patent prosecution is describe improved feature, especially in use of AI technology as written in red letter in the slides. The invention related to monitoring the operations of machines. Key tab decision is claim 1 address a problem specifically using several artificial intelligence technologies to monitor the operation of machines. And Peter also quoted the case law shown in the slide. Next, case 4. Tips in the patent prosecution is in claims clarify specific technical phrase in which machine learning model is used. Furthermore, in the specification, describe improvement in the specific technical phrase through machine learning model. P-tab decision is the claim is directed to generating and training an object classifier that can be used for analyzing objects posted to the online social network and associated with particular user. The specification also explains how the claimed use of comments associated with the online social network objects in training the object classifier algorithm results in an improvement. Next, case 5. Tips in the patent prosecution is describes in claims not only a step of predicting or determining something, but also a step of outputting specific result by utilizing machine learning model. In the notice of allowance, the examiner recognized that transmitting notification is a practical application of the abstract idea. Based on this point, the examiner could regard this invention as an improvement in computer capability. This is summary of tips regarding 101 rejection. In the meeting with USPTO, a general manager from Examination Quality Assurance Department said, these case studies are practical and useful, especially case 2 describe technical details related to AI-related elements. For example, special combination of dictionary requests. Then I will move on to second topic, non-obviousness. I will skip response to the request for comments today. Anyway, our concern is actual determination of non-obviousness regarding AI-related inventions in the patent examination. Therefore, we have studied case 6 and 7 and suggest tips in the patent prosecution in applicant's view. Okay, let's move on. Actual case. Case 6 is an invention related to object detection for vehicles such as a car that use capturing image and audio data. To perform object detection, the invention inputs these data into neural network. The examiner cites two prior arts. One prior arts disclosed using audio data for object detection. Another prior arts disclosed using neural network for object detection. Combination of prior arts and logic of the relation is this example, I think. Against the rejection, the applicants amend claims to clarify detailed input and output of neural network as shown in slide. As a result, the examiner issue allowance. Although we can't judge which elements were persuasive for examiner because the examiner cites almost all of amended claims elements in notice of allowance. From this case, we think clarifying the detailed input and output of a neural network in claims is good steps in the patent prosecution to assert non-obviousness. Next, case 7 is an invention related to cryptographic key materials trustworthy, which identify a model that predicts whether a presented graphic key material meets at least one debasing condition. The examiner cites prior arts that disclose the probability of debasing condition. Against the rejection, the applicant asserts that the prior art does not disclose the predictive aspects of the claim. Prior arts already set the score when the debasement condition occurs, therefore, there is nothing predictive. From this case, we think arguing that no prediction by machine learning is disclosed in prior arts is good tips in the patent prosecution to appeal on non-obviousness. Well, this is a final slide of the presentation. Summary tips regarding 103 rejection in applicant view. In the meeting with PTO, a general manager from examination quality assurance department said these case studies are practical and useful, but however, saying it is case by case. Okay, this is end of my presentation. We welcome your opinions and comments on these tips. Now I would like to move on Q&A session. Do you have any questions and comments?
Thank you, Satoshi-san. This is Todd Baker. This was a very informative discussion. Looking at your summary of tips regarding 103, where you recommend clarifying detailed input and output in the claims. Do you think that that approach is also useful in addressing potential 101 issues by having a specific solution?
Yes, I agree your opinion. Especially like case 5. Case 5 is a 101 rejection case study, and in this case, applicants describing as transmitting a notification that is equal to output from like machine neural network algorithm. So from this case, I think clarifying detailed input and output of neural network is also used for one rejection, as you said.
Okay, thank you. We have another question from Mel Garner. He asks whether as AI elements become better known, will it be more difficult to overcome 101 rejections?
Yeah, I think so too. From now, the case is extract from 2013 to 2020. So now AI-related elements and technical feature it becomes common. So now these tips can be useful not only case by case, I think. But in case 2 is practical and useful from the USPTO's opinion.
Thank you.
Yeah, thank you for your opinion.
Do we have any additional questions for Satoshi-san? Okay, thank you very much. I think we will now turn to our third topic.
Okay, thank you for everyone.
Thank you, Moriyama-san. Our next speaker is Irfan Latif from AIPLA. He will discuss the impact of COVID on patents and litigation.
Can you see my slides?
Yes, we can see them.
Okay. はじめまして。名前はアルファンです。よろしくお願いします。I will be discussing today some statistics and overview of the progression of patent litigation, IPRs, as well as patent prosecution at the Patent Office during 2020. The majority of the slides are graphs of the delays or speeding up of certain activities during the course of the pandemic. As a lot of the practitioners are here attending this presentation, I welcome input from others with regards to their experiences either during the presentation or afterwards. So one of the interesting statistics that we will start with is the amount of patent litigation that occurred in 2020, and it actually went up in terms of district court filings, IPR filings, as well as ITC filings. As you can see, the ITC increased by 30%, which is pretty high to have 54 ITC proceedings going on in a year. The high mark was around 71 in 2011, so there's a definite increase in ITC proceedings. 11% for district court proceedings, up about a little bit over 400 cases as compared to last year, and the PTAB was up 16%. My feeling was once after the things settled down in terms of the effect of the pandemic regarding trials maybe being pushed off, that a lot of plaintiffs decided it was time to file and try to make sure that they had things on file, maybe in case the defendant went bankrupt later because of how the pandemic went. I mean, there was a lot of uncertainty, and so I think that made a lot of plaintiffs decide to file sooner rather than later. In terms of the origins of parties in 2020, I just wanted to highlight where Japan was in terms of the various states and countries where parties originate from. And Japan was 10th overall with 267 cases, which is much more than many other United States, and falls behind India, China, and South Korea in terms of foreign parties. As you may already know, the majority of the cases in 2020 were filed in 3 districts: the Western District of Texas, the District of Delaware, and then the Eastern District of Texas. You may already know the Eastern District of Texas as being a popular plaintiff's venue for over a decade, if not more, and the Western District of Texas becoming more popular over the past 2 years, and Delaware becoming more popular in recent years because of various companies incorporating in Delaware, and so people sue there for venue reasons. The district I'm in, Central District of California, is 4th with about 7% of the cases, and the Northern District of California, which is a popular defendants forum, is looks like around 6%. This next slide shows the average time to claim construction, and it does a comparison between 2019 and 2020 for various districts. And it's interesting that it flip-flops between various districts. In Central District of California, it took longer to get a claim construction in 2020, but in District of Delaware, it took less time than previously. The Western District of Texas there at the bottom has one of the quickest times to claim construction with 369 days. The Southern District of New York had 107 days as the average time to claim construction, and I apologize, I hadn't dug into the reasons why that may be. It may be related to the number of cases it had or some other issue with the cases, but that seems to be a little bit of an anomaly in these statistics. Average time to trial obviously increased, I think, for most of the country due to COVID. Most of the trials were pushed out when they came up for scheduling conferences or other issues that came in the case. Central District of California went out in 2020 out to 1,365 days, It increased in Delaware, New Jersey, Eastern District of Texas as well. And if you look at Western District of Texas, in 2020, it is 636 days, almost a little less than 2 years, which is why that is a popular venue. And judges in COVID, I'm going to talk about this a little bit later, but here are some statistics. Judge Albright in the Western District of Texas, who has publicly said that he's making the Western District of Texas a patent forum, a serious patent forum, and many plaintiffs have taken him up on that. And his time to trial is 567 days. And you probably want to look at that in comparison to Judge Gilstrap in the Eastern District of Texas, which is at 556 days. There seems to be, there seems to be sort of a competition between both of them as to who can have trials quicker and who could have more trials during COVID, which we'll get to in a few slides. So now I'm going to switch to IPR proceedings, and the number of instituted IPRs went down, as was the general trend prior to 2019. And it went down farther below than previously, down to 56% of IPRs being instituted. Some of that, but I don't know the exact numbers, some of that may be because of the FinTIV case and the discretionary denials of an IPR institution that is now being challenged by various parties. But just as a small overview, under the FinTIV case, a patent owner can request that the Patent Office discretionarily deny institution of the petition based on a variety of factors, one being that the case would normally get to trial in the district court before the final written decision in the Patent Office would come out. And that is one reason why the Western District of Texas is popular, because they schedule cases to go to trial around 18 months, which would be quicker than a final written decision would normally be issued in the Patent Office. This slide is similar to the last one in terms of the number of institutions by patent as opposed to by petition. And I've also included a slide here on just what the 2020 outcomes by petition were. Institution was denied in 36%. The final written decision where all claims were patentable were 6%. There was a mixed result in 7%. And in 22% of the cases, all claims were held unpatentable. Looking now at proceedings in front of the Patent Office, the number of applications and grants seem not to have been affected too much by COVID. The number of applications actually increased, and the number of patent grants stayed relatively the same. So in terms of interactions with the Patent Office, nothing seems to have slowed them down in terms of reviewing patent applications or granting them. although not directly related to COVID, I thought I would include the number of patent grants by country, and just to show you where Japan was. This past year was 52,421 patent grants, which was down 3.6% since 2019. Most countries were less this past year than the year before, except for China, which increased by 11.3%, and Taiwan. And so COVID may not have disrupted the patenting process in China and their development of patented technology. This is a graph of first office action pendency. And I've looked at these numbers pretty carefully, and there is only a, it looks like actually that first office action pendency decreased slightly from 2020 to 2019. I wouldn't call it, very significant in the decrease. It kind of follows the same pattern in terms of in September, the fiscal year ending, they have less, they try to get rid of, I guess, a lot of office actions get issued then, and that trend continues in September 20. And then by December, that starts increasing as people take holiday. This next graph shows the total patent pendency from January 2019 to December 2020. And again, there is a slight decrease in the amount of pendency from 2019 to 2020. So I believe overall, the efficiency of the Patent Office may not have been affected from COVID as much as other areas, since everyone pretty quickly picked up working from home and working efficiently from home in most of the states. And then this slide looks at the office time versus applicant time in office actions. And from 2013 to 2020, it does look like the efficiency or the amount of time spent examining applications between the Patent Office and the applicant has gone down and continued to decrease slightly in 2020. I was going to mention just a few cases that actually went to trial in during the COVID. The first trial that I'm aware of was in the Eastern District of Texas in August of 2020. It was Veranex v. Apple, and Judge Gilstrap was deciding a motion filed by Apple to delay the trial. And they had presented a doctor's declaration indicating that it was not safe to have a trial and have people that close together in the trial setting. But as noted here, Judge Gilstrap rejected that declaration, stating that it's not possible to have a no in-person jury trial at any time, which was what the doctor was saying with regards to being during the pandemic. And then he faulted the doctor for not making a prediction on when it might be safe to do so. So he went forward with the trial and had various safety precautions in place. And the trial was eventually held August 3rd to August 11th. The jury returned a verdict that Apple had infringed the asserted claims and they were not invalid. And that verdict was $500 million, which is exceedingly high. There was a trial later in the Eastern District of Texas that was handled by one of the Kenobi teams, and Joe Ray was involved with that. So I will welcome his comments about how that trial went during the Q&A procedure. The other trial that people have been waiting for is a trial in the Western District of Texas during COVID. There was a trial, I believe in October, when the COVID numbers had decreased in the Western District of Texas. And then as they increased in December, cases were put on hold. And right now, the case that is going to be next up for trial will be VLSI v. Intel on February 22nd, 2021. In this case, all parties and other trial participants must wear masks, social distance, and most notably will be tested for COVID each day of the trial. And of course, the parties are going to bear the brunt of the costs for some of these, for the testing and for other things that are called for to allow the trial to operate during this time. And then finally, interestingly, there was a Zoom trial, which was done in the Western District of Wisconsin. It was Ironburg v. Valve Corp. This case, I believe, had to do with gaming consoles. And the trial was done under Zoom, so the summons for jurors indicated that they would have to participate in the jury from their home with their computer or other technology that they were going to use for the Zoom meetings. And clerks met with the jurors online and walked them through the tutorials of how to view and the trial and kind of some of the protocols that they needed to follow. And when one juror was interviewed, who had been a juror during regular times in a courtroom, said that it was actually better for him because you got to see the exhibits clear and the other documents, and you could see the witnesses' faces more clearly than you would in a courtroom. He mentioned, though, that deliberations over Zoom were kind of difficult, but eventually that jury found infringement with a verdict of $4 million. In terms of other trials that are going on, I believe most districts, other than probably Western District of Washington and Texas districts, have postponed most trials until 2021, because even if the jury trials can occur in person, most of the jury trials that will occur first will be criminal trials. And then after that criminal docket backlog has been eased, they will then begin to have civil trials. So I think it's still going to be quite a ways away from having jury trials in courtrooms be the normal. That is it. Thank you very much for your attention. And I welcome any questions. And if Joe wants to talk about their trial in Texas, that would be, I think, valuable for everyone to hear.
Thank you, Irfan. My trial that I had in October during COVID was conducted before Judge Gilstrap, and there were some rules that everybody had to comply with in his courtroom. It was not an enjoyable experience because all the jurors had to wear face shields. All the observers had to wear masks, and only the lawyers sitting at counsel table, which I think were limited to 4 people, were the only people not with masks on, and the witness, when testifying, did not have a mask on. And the trial was timed that each side had 13 hours to present their testimony. There was one other trial I think you left off. Judge Massant had a trial in late August where the defendant won. There was a defense verdict for Amazon for Judge Massant, and that was the trial that preceded ours. And so there's been a few trials, but Texas has shut down. They're not having those cases as they were in the fall. I will yield to my fellow board member, Bob Stoll.
Hi. I just wanted to say that I was participating as an expert in a trial in New Jersey. It was a bench trial. I will admit it was a bench trial, but it was all done remotely, and it was brilliant. And the judge even is on record of saying she thought it was outstanding. And what the attorneys did was they sent me their computer and 2 other screens. They sent me the backdrop. They sent me the headphones. They sent everything. They controlled the screen. The judge said that she could see the reactions of the different people, and she was able to form an opinion. It went very smoothly, and I was really impressed. Just wanted you to know.
Thank you, everyone. Are there any questions from the audience for Irfan?
Also, if anyone has some counterpart information regarding trials or prosecution in Japan during the pandemic, I would be interested in hearing how it's going over there.
We have one question from Joe Rape. This looks probably for Bob. Did the parties have to agree to a Zoom jury trial? Well, I'm sorry, this is probably for Irfan then. Do the parties have to agree to a Zoom jury trial?
I didn't look into that, but I would think they would have to agree to it because of some of the credibility determinations that you're going to make, and the jury needs to see that person and see their reactions. And over Zoom, depending on who's controlling the camera and what angle people are at, it may not be the same as live. Live is always better.
Great. Any other questions for Irfan? Great. Well, thank you very much for your informative presentation.
Thank you.
So our last program for today is a panel discussion regarding Section 101. Originally, it was going to be moderated by Todd Baker. Unfortunately, he had to leave us a little bit early today for the reasons in the chat box. So I will try to take his place to moderate this. But the people who really are the most important are the panelists. One of the former presidents of AIPLA, and that's Mel Garner. And also one of the board members this year, Bob Stoll, who is also our liaison. So we're very much looking forward to hearing their thoughts about Section 101 patentable subject matter. So you can just give me one moment. So gentlemen, take it away.
Mel, you want me to do the first slide and then you start?
Sure.
Okay. Jason, could you move to the next slide? So this is basically what we're going to be talking to you about. Mel is going to do a phenomenal job talking about Flute to Deer to Mayo and Alice. And we're also going to talk about the key pre-guidelines 101 cases, and that's pre-January 7th, 2019. And in addition to that, the clarification that was put out in October 17th of 2019. We're going to talk about structure and guidelines of medical examples and how you can kind of formulate your claims to get them into the proper shape that the PTO lets them move. And the same is true with the computer examples. And then we're going to talk about post-guideline cases Ariosa and American Axle, and maybe a couple of new ones. And then we're going to talk about conclusions and where we're going from there. Next slide, and to Mel.
Thank you. Excuse me. Satoshi-san gave a good explanation of how to handle 101 problems with respect to artificial intelligence. And what we're going to do is step back and do it on a much broader basis to cover all technologies. And as a platform for doing that, I wanted to just develop some of the background in this area. So the United States has a statute that covers what's patent eligible subject matter. It's Section 101, and I'm sure you're all familiar with it, and it's not a problem. The problem is that the judiciary has created exceptions to this, and they can be considered abstract ideas, mental processes, laws of nature. But you should be careful because often the judiciary will refer to these exceptions using different terms, so you're never quite sure what you're going to get. Next slide. So this case goes back to 1978. It's Parker versus Fluke. It was one of the early decisions about where people thought the Supreme Court was going to give us a definition of whether computer programs were patentable. In this particular case, the claim was directed to a computer that was used to execute an equation which updated an alarm limit during a catalytic conversion process. So essentially, if something was going wrong in the conversion process, the computer would get signals. It would calculate whether or not it was a safety condition, and it generated a number which was the alarm limit. But the claim itself didn't do anything other than just generate the number. And the Supreme Court, in deciding the case, said that the process was unpatentable, not because it contained a mathematical algorithm as one component, but because once the algorithm is assumed to be within the prior art, the application considered as a whole contains no patentable invention. And I think this is, if not the earliest, is certainly one of the first inventive concept cases. What the court is essentially doing is looking at your claim, taking the algorithm out, and looking at what's left, and requiring there to be an invention in what's left. And that, you'll see, was in 1978. And if we go to the next slide, in 1981, the Supreme Court again addressed the subject matter. This time it was the decision by the Chief Judge Rehnquist, and the dissent was by Justice Stevens. Here, the claim was directed to a rubber molding process utilizing a digital computer and an equation to determine the proper time for opening the mold and then actually opening it. So you can see that there was an action step involved in this. So the court first said that the view that a claim drawing the subject matter otherwise statutory does not become non-statutory simply because it uses a mathematical formula. So when you look at it in this case, there was a rubber molding process and they stuck a computer on it. That didn't make it non-statutory just because there was a computer stuck on it. They also addressed the inventive concept. Here, this court said the novelty of any element or steps in a process, or even the process itself, is of no relevance in determining whether the subject matter of a claim falls within 101. So they categorically rejected the inventive concept. And not surprising, Judge Stevens issued a dissent in the case because they essentially thrown out what he had said not 4 years ago should be the law. Slide 6. The next case was, going on in the same case in Diamond versus Deere. The court said that a mathematical formula as such is not accorded the protection of our patent laws, and this principle cannot be circumvented by attempting to limit the use of the formula to a particular technological environment. So merely using the preamble of your claim to set up an environment that's technological won't save it, even under Deere. And they said insignificant post-solution activity will not transform an unpatentable principle into a patentable process. Activity beyond a formula must be significant, but does not need to be inventive. So here there was a clear dichotomy between the two cases where Fluke was looking for, beyond the formula, there being some inventive concept, and Deere saying there's got to be significant concept, It doesn't have to be inventive. It doesn't have to be even novel. Next slide. And we went for about 25 years, merrily thinking everything was resolved and happy as clams, only to run up against the Mayo case in 2012. There, the court found ineligible for patenting a method of giving a drug to a patient, measuring metabolites of that drug, and with a known threshold of efficacy in mind, deciding whether to increase or decrease the dosage. As you'll see later, there's some important concepts here. One was having a threshold in mind, which screams mental steps, and then deciding. So somebody's making a mental step of deciding one thing or not. But the court went on to say, purely conventional or obvious pre-solution activity is normally not sufficient to transform an unpatentable law of nature into patent-eligible application of a law. Post-solution activity that is purely conventional or obvious cannot transform an unpatentable principle into a patent-eligible process. Now, this is directly opposite to what Deere said. Deere said it didn't matter whether it was obvious or old or anything. It mattered whether it was substantial. Yet the Mayo court emphasized that it was applying both Deere and Fluke. But these two cases are irreconcilable, and that began the troubles that we're in today. Next slide. So what Mayo said the test is essentially a two-part test that we've all become familiar with now, that you identify claims that are directed to a judicial exception, and then you evaluate what additional limitations such claims recite to provide an inventive concept, which is all the way back to the 1978 Fluke case. Another way of saying inventive concept could be to say a practical application. Next slide. The Alice case, a lot of people refer to that as being a patent eligibility test, but I don't think of it that way. Essentially, Alice just followed Mayo. It's in a different context because in Alice, it had to do with a computer-implemented electronic escrow service facilitating financial transaction. But it purely relied on the two-step test from Mayo. It relied on all the concepts in Mayo. And in fact, I believe Justice Thomas, who wrote this opinion, said he didn't know what abstract was, and he essentially was relying on whatever the other cases had said and was going to apply it in this case. So the question is, if the Deere procedure were used, would the use of a general purpose computer be considered substantial? And I think that Alice stands for that proposition, that it wouldn't. That essentially, the only way you can carry out a computer program is with a computer. And so therefore, just using or claiming a computer in your claim is not going to be substantial. Next slide.
Mel, before we go to the next slide, now that we have the Supreme Court's decisions in Mayo and Alice, do practitioners still need to look at Fluke and Deere, which, you pointed out some inconsistencies, but do they still provide any guidance?
I think they do. I think when we get into the guidelines, you'll see that I at least try to make a stab at showing how they're relevant to the guidelines. And also, you never know. If you have the opportunity and if all you've got is to be able to argue Deere, then you argue what you've got. So you at least ought to know that it's available. It's a Supreme Court decision that has never been overturned. And so it should be available for you to use.
Thank you.
So I'm going to talk about a couple of cases, not too many, but I'm not going to get into the specific details of the particular case. What I want you to remember from my piece of the discussion is that your application needs to tell a story. Your specification needs to tell a story. And that story is how you are taking a technological problem and solving it with a technological solution. That is the most important thing to get out of this from my aspect of it, dealing with computer methods. So what you need to do is you develop in your specification the problems that are perceived and that are understood by those who are technologically skilled in that particular art, and how your claims solve that particular problem technologically. And first example here is FinGen. And what I want you to see is the red section, which talks about specific steps that accomplish a result that realizes an improvement in computer functionality. So you are changing how the computer operates, and that type of case is deemed to actually survive 101, even pre-guidelines. Next slide, please. So Berkheimer is another case that came out just before the guidelines came out. However, Director Yanku used Berkheimer, and he used them in his guidelines, and he used them specifically to talk about step 2. That was actually the second step in the analysis. We call it the Mayo type of analysis, the Mayo-Alice type of analysis. But go down to the third bullet and take a look at it. With respect to the Mayo analysis, the court considered the elements of each claim, both individually and as an ordered combination, recognizing that, quote, whether a claim element or combination of elements is well understood, routine, and conventional to a skilled artisan in the relevant field is a question of fact. Why is that so important? Well, courts were dismissing these cases with summary judgment frequently. That's how they were getting rid of them. And what this statement says is that, in fact, you can't always do that. You actually are going to have to take a look into whether something is a well understood, routine, or conventional to the skilled artisan. And that's something that's a fact determination. And it's something that actually makes it much more difficult to get rid of a case right away until there's some fact finding that occurs. So it actually kind of diminishes the benefit of using these 101 claims or issues early in the case to dismiss it, because now there has to be a fact analysis anyway. People jumping in to try to get rid of it very simply are having difficulties doing that. Next slide, please. The other case that is moving that I wanted to discuss right here is the Core Wireless. And again, I want to follow the red line. We're talking about a technological solution to a technological problem. The claims contain precise language delimiting the type of data to be displayed and how to display it, thus improving upon the conventional user interface to increase the efficiency of using mobile devices. You're seeing that you're changing the devices, you're improving the capability, and that's why they're allowing this to pass through 101. Next.
Right here, Bob, if I can ask you a question.
Sure.
You've emphasized the technical solution to a technical problem a few times. Is it fair to say that claims directed to a technical solution for a technical problem are always patent eligible?
I'd never say anything is always in any practice that I've ever had. But I'd say you got a very good chance of surviving 101 with that type of analysis. So I won't go always, but I'm going to say it's what I do and it's what I tell my friends to do.
Great, thank you.
Okay, I'm going to pick up here. What the Patent Office did, and I think this was a very wise decision on the part of the director, is they said that there are too many cases like the ones that Bob went over, and there are legions of them, for an examiner to try to figure out how to decide whether or not something is patent eligible. So he came up with guidelines, and what the guidelines basically did is to try to simplify it and codify it into a form in which the examiners could deal with it. And they made one very important step. Step 2 of Mayo, they divided it into 2 steps. And I believe that the first step, step 2A, is actually the Deere case, and step 2B is Fluke. That what they did is they sort of squeezed Deere back into those eligible subject matter cases by making it the first part of the step 2. So if you look at this slide, the first step is to decide whether the claim recites a judicial exception, and those are the things that are laid out. And then step 2, and this is the new part, that the step 2 is to determine whether the exception is, quote, integrated into a practical application by additional elements of the claim without consideration of whether they are conventional or obvious. If integrated, the claim is patent eligible. And I think that that's dear because it doesn't no longer relies on the other elements being unobvious or conventional. Then step 2B says, are the additional elements more than well-known or routine or conventional, either alone or in combination? And that would be the inventive concept. So what you do is you see if you can get through with deer, and if you can't get through with deer, maybe you can get through with fluke. Slide 14.
If I could interrupt here, and this question is for both you, Mel, and Bob as well. As we all know, Director Iancu has stepped down from his leadership of the USPTO. Do you anticipate that new leadership will make any changes to these guidelines that you've laid out here?
Good question. So far as I know, a director has not been named. I thought Iancu did a marvelous job. In fact, I thought the last three directors we had have all advanced the ball significantly over what had gone on in the past. I would hope not. I think that for the patent office to take a patent positive position, I think is good for the economy and is good for patent attorneys for sure. Bob?
I agree with Mel. My answer is a little bit longer than that. I think that in fact, these two guidelines that Director Iancu came up with were brilliant. I really like them a lot, but courts have said that they're not bound by those guidelines. And in fact, they aren't. So for me to be able to get a case out of the Patent and Trademark Office, but not have it enforceable in the court doesn't serve my clients very well. So I think the next director has to do more things. And some of those things, I think, relate to providing studies that show the impact of 101 to the domestic economy and actually to the international economy. You know, you've got COVID running rampant right now. If you had more protection for diagnostics, it's possible that someone would have been able to develop a test that told us what 15% of the population would have problems with COVID. And then we go and treat them and everything is much easier, much better, much more efficient, and people live longer. So I think we've got to show that the problems that are occurring because we're not having an effective 101, I think we've got to be out there doing things with studies and anecdotes, and maybe even some sort of governmental task force to look at these types of issues and get them going, because Iancu's guidelines alone, while good, are not going to do it.
Okay, next slide.
Sorry.
This is the flow chart for the guidelines, and it's essentially the same one that you saw earlier. And so we can just skip over it. Next one. Okay, so now getting into the details of the guidelines. So one of the things that the Patent Office did is, instead of trying to, in words, say what an abstract idea is, just like Justice Thomas, the examiners have a hard time figuring it out. They essentially made a list. So if you're an examiner, all you have to do is look it up. If it's in the list, it's abstract. If it's not in the list, you at least have a good argument that it's not. And so this list includes, for things that are abstract, organizing human activity, fundamental economic principles like hedging, insurance, mitigation risks, commercial or legal interactions, contracts, and things of that sort, managing personal behavior, mental processes. And mental processes is important. Things like observation, evaluation, judgment, those come up a lot in diagnostic cases. So you'll know if you're an examiner and you've got a diagnostic case, and there's somewhere in it where they say evaluate the results of the test, you got a mental process step, you've got an abstract situation, and you're going to have to apply the guidelines. Next slide. So we talked in step 2A about integrated. What does that mean? So the guidelines say that the judicial exception is integrated into a practical application if an additional element does one of 5 different things, at least one of 5 different things. One reflects an improvement in computer or other technology, and that's a lot of what Bob said earlier with those earlier cases where you're improving computer technology. If it uses a judicial exception to affect a particular treatment or prevention of a disease or a medical condition. And that's kind of tricky because Mayo was kind of a diagnostic thing, treatment thing, and that didn't survive. So you're going to see that you have to have a little bit more than just the ability to diagnose or treat a condition. Uses a judicial exception in conjunction with a particular machine or manufacturer that is integral to the claim. So this is not going to apply to your general purpose computer. It's going to have to be a specialized computer or a special machine in which it's combined. If we go to the next slide, we'll see the other two. If it affects a transformation or reduction of a particular article to a different state or thing, that's a classical definition of a process. And so processes are easily going to be transforming a law of nature into the claim. And the final one is kind of a catch-all. If none of the others worked, here's the one you try. It uses the judicial exception in some other meaningful way beyond generally linking the use of the judicial exception to a particular technological environment. If you can link it to a particular application of the law of nature, I think you're going to be okay. But just linking it to a technological environment is not going to help you. Next slide. I got lost. Okay, so now step 2B, which is the second part, is the question is, does it amount to an inventive concept? That's fluke. Do the claims require significantly more than the recited judicial exception? For example, because the additional elements were not well-known, routine, or conventional, either alone or in combination. An examiner might consider data gathering steps to be insignificant extra solution activity in step 2A, finding the judicial exception is not integrated into a practical application. However, reconsidering the data gathering steps in step 2B, the examiner could determine that the combination of data gathering steps occurs in an unconventional way and therefore include an inventive concept. So you can see that with this, and this comes directly from the guidelines, they show you how you can actually fail under DEER and yet be able to succeed under fluke by following the guidelines. Next slide. So the January 2019 guidelines came out and people were pondering them, and the office thought they needed some clarification. And so they came up with the October 2019 guidelines, which were meant to clarify them. And these the guidelines also provide a number of examples, and we'll talk about them in a minute. But the guidelines from October say that when determining whether a claim recites a mathematical concept, whether the claim recites a mathematical concept or merely includes limitations that are based on or involve a mathematical concept is an important distinction. A claim does not recite a mathematical concept if it is only based on or involves a mathematical concept. And that will become important when we talk later about the American Axle case. So not all methods of organizing human activity are abstract ideas. For example, if you define a set of steps for combining particular ingredients to create a drug formulation, that's a certain method of organizing human activity, but it's also a process that's patent eligible. Next. So now if you talk about the mental processes part. So claims don't recite a mental process when they do not contain limitations that can practically be performed in the human mind. And they give a GPS position location is presumably is hard enough that you can't do it in your mind, and you need a processor in order to do it. So claims that can be performed by the human mind, even though the claim requires a computer, is covered by the mental processes. So claims that are only partly performed by the human mind are also suspect. The use of a physical aid, such as pen and paper, to help perform mental steps does not get you out from under the mental process limitation. Next slide. So you can integrate the judicial exception by applying it to affect a particular treatment of or protection from a disease. This particular part of the guidelines is very good for those doing biologics and doing methods of treatment, because it says that you look to see if the treatment is specifically identified, such as a particular disease, and then does the treatment have more than a normal or insignificant relationship to the exception? And finally, does the treatment impose meaningful limits on your judicial exception? If you can get through those, then you will be able to get your method of treatment or your diagnostic method allowed. The next slide. So a practical tip. So in drafting an application and claims, as well as in responding to office actions, always provide a basis and argue both steps 2A and 2B. We know that step 2B is specifically endorsed by the Supreme Court in both Fluke and Mayo and Alice. So you want to be able to have that argument in your amendment. So if your case goes into litigation, you'll have that to fall back on. But you can argue step 2A as well in the hopes of getting your claim allowed when in a situation when the examiner may not allow it. And then if you're a first-class litigator like Joe Ray, you say, my claim's got both step 2A and 2B. There's no way this is not patent eligible subject matter.
Next slide.
Next slide.
I think that's very good advice, Mel. I really think that that's something everybody should take to heart. The January 7th guidelines were basically related to issues dealing with software. And in fact, they, for the first time I saw anywhere, quite in detail, talked about what an abstract idea was. And I don't think I'd seen that in too many cases before, and I never saw it put together that way. The ones in October were more towards the biotech pharmaceutical area. And this example is from the October one, but it really kind of turns on a mathematical concept. So again, I don't want to talk about the whole thing, but I want you to say that it's a method of treating, and it talks about calculating, and then it talks vaguely about administering. So you're calculating some sort of mental activity, and then you're administering, but you're not doing anything specific. It doesn't tell you what you're administering or anything along those lines. So it is deemed to be ineligible as no product of nature is recited. However, the calculation is an abstract mathematical concept, and it can be performed in the human mind. And the relationship represents a law of nature. The additional administering step provides no particular treatment that would integrate the calculation into the political application, into the practical application. Next slide, please. So there were dependent claims in this hypothetical, and they talk about the treatments themselves. And that was deemed to be eligible because they integrate the calculation into a practical application. So I think that that's something to be taking note of that could cause divided infringement situation unless the person doing the calculating is also doing the administering. So you got to be careful how you formulate your claims and what you're doing there. But I think they're telling you that when you add the treatment piece to it, you have much more likelihood of finding allowable subject matter. Next slide, please. Here was another example where a method of administering rapamycin to a patient identifying as having NS3. It's eligible because while rapamycin is a naturally occurring or nature-based product, the claim is not directed to the compound itself. The claim is directed to it, you would have to do a markedly different analysis. The general rule is the claim is not subject to a markedly different analysis for natural-based products used in the process. The step of administering is not a judicial exception. It is not a law of nature. Next slide, please. Now.
Okay, back to me. Am I stepping on you, Jason?
No, you're good.
Okay, good. If you take a quick look at this claim, you can see this is Deere. It's a molding apparatus. You obtain measurements of the temperature of a mold. You do a calculation using the same equation that they used in Deere, the Arrhenius equation. But here you stop. You determine the extent that the polyurethane is cured as a percentage. And so determine is one of those key words that's going to get you in trouble. And there's no action step in there. You just figured something out. So taken deer and pushed it back so it's more like fluke, where all they did is calculate the limit. And the analysis that the author suggests is the same thing. They say that calculate an equation or abstract mathematical concepts. They can be performed by the human mind. This Arrhenius equation is a law of nature, and determined in this particular case was a conversion from one format to another. So, but it was still a mathematical concept. Next slide. So, looking at it under step 2A, the additional step of repeatedly obtaining measurements is a mere data gathering step. The controller is like a general purpose computer and does not negate the mental process. So the guidelines go on to say the courts have made it clear that mere physicality, that merely because you have something physical or tangible won't get you past the 101. And there were days in the past where we thought that's all you needed to do. That it's really not a relevant consideration now. So the additional elements do not integrate the judicial exception into a practical application. The controller and his data gathering are well-known insignificant extra solution activities, so that doesn't get you past the fluke test. Next slide. Here's a new claim. So this is a dependent claim, depending on a claim 1, and it goes on to say that you're sending control signals, and the control signals instructing the apparatus to open the mold and eject the molded polyurethane mold. So we have signals that are created, and we have action, that is open the mold and eject the molded product. And that's what they say that under the 2A or under the DEER analysis, it integrates the judicial acceptance into a practical application, which prior molding is improved. Next slide. So here's another claim. Claim 3 is another dependent claim. And it says a means for temperature measuring that repeatedly measures the temperature of the mold. So you can see this is all internal stuff where they're measuring, but they're not doing anything outside of the apparatus. So in looking at this, they say the means for temperature measuring construed under 112F, which we talked about earlier, is an ARC-XY thermocouple. It provides only data gathering. It's an insignificant extra solution activity. The thermocouple alone or in combination with the controller failed to integrate the judicial exception into a practical application. So these thermocouples are well known. So repeatedly measuring the temperature of the mold with those thermocouples, however, was not well known. In other words, while the thermocouples were known, use for the thermocouples for this purpose was not well known. And they say, therefore, these thermocouples provide for an increased accuracy in the operation, and under the fluke doctrine, it makes it patent eligible. So we can see up above under 2A2, DEER, we lost, but under 2B, we won because the apparatus used was not well known or common. Next slide. So this is another very similar kind of claim. It's got a controller, it's got a mold, uncured polyurethane. You send your control signal. You repeatedly obtain temperature measurements. You compare the temperatures to a target temperature, and you maintain the temperature of the mold within 2 degrees of the target temperature by sending a control signal to the apparatus, blah, 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 blah. So you can see that you're doing a lot of stuff down in item D, rather than simply producing a number. And you're actually ending up with control over the mold. So next slide. So here, under step 2A, compare the obtained temperatures is an abstract mental process. So that doesn't get you there. Under step A2, the controller is recited so generally that it's merely an instruction to apply the exceptions. It is at most an attempt to link the use of the exception to a technological environment. However, sending a control signal to regulate injection and to heat the mold is considered a field of use. However, it also is insignificant extra solution activity. Finally, they say that repeatedly obtaining temperatures is again a data gathering step. Next slide. But when we get to our limitation D, that's the good sauce. So maintain the temperature of the mold within 2 degrees by sending a control signal and using it to take corrective action and control the mold. So that integrates the judicial exception into the overall control. So that would be a patent eligible claim. So what I have is 2 very recent decisions, ex parte Patel. It's a PTAB decision, and they specifically use the guidelines 2A and 2B in order to arrive at a patent eligibility determination. In a very recent Federal Circuit case, actually from February the 8th, so that's how recent it is, in a footnote, the court said that the guidelines are not law and are not binding, I didn't spell binding right, on the Federal Circuit. So I think the 2 things you can take away from that. Number one, they're saying, hey, this is not law, patent office, you can't make me do it. But they didn't go to the effort of saying that the guideline was wrong. They didn't point out any particular part of the guidelines that they wouldn't accept as being acceptable under the court's jurisprudence. Next, I think it's back to Bob.
Yeah, and this case is also fairly recent, August 3rd of 2020, Illumina v. Ariosa. And in the original March 17th, 2020 opinion, the court found that the claims were directed to methods of preparing plasma to isolate and amplify extracellular fetal DNA based on the fetal DNA strands in the maternal plasma, where directed to patent eligible subject matter under step 1 of the Supreme Court Alice Mayo inquiry. They then modified that decision, and in modifying it, the majority added that support for its conclusion that the claims were not directed to the natural phenomena of shorter fetal DNA strands, noting, for example, that the recited human engineered size discrimination thresholds that were not dictated by the natural phenomena as the natural size distribution of fetal and maternal extracellular DNA overlap each other. Next slide, please. The majority found that the claim size threshold were human engineered parameters. So you had human intervention to balance the practicalities of moving enough maternal DNA to enrich the plasma while leaving enough fetal DNA to allow for testing. And of course, Judge Renya dissented, but we do have a majority opinion. Next slide.
So Bob, on this case, I think it's important to point out the Ariosa v. Sequinom case, where the Federal Circuit concluded that method claims directed to using cell-free fetal DNA in maternal plasma to diagnose fetal abnormalities were patent ineligible. Can you reconcile this Illumina case that you just discussed with the holding in the Ariosa case?
My personal opinion is it is a bit tortured, because I think that other case was badly decided. I really thought you had something that should have been deemed to be patent eligible. But what you also have that's added here a little bit is the size discrimination thresholds, which were part of a human concept and not something naturally occurring. That being said, I also thought the other Ariosa case should have been patent eligible.
Thank you, Bob.
You're welcome.
Okay, back to me. This is the American Axle case. It was decided in July of 2020. I will skip to the punchline, which is that it's been appealed to the Supreme Court. Cert was granted, and I looked it up today. Actually, briefing has been extended to March 31st, I think. So we will get some kind of a decision. Why did the Supreme Court pick this case to decide? Number one, the case I think is badly decided, and maybe they'll fix it, but maybe they'll make it worse. The other thing is that the technology is so simple. Maybe they figured they could understand it. So rather than taking one of these complicated cases, they would take this case. So without going through the details of the claim language, it's a drive shaft. It connects 2 pieces of equipment and allows one to turn the other. And the inventive feature is something called a liner. And what they found is that these drive shafts tend to vibrate. And if you take a liner and put it in the right place and size it the right way, you can essentially reduce the amount of vibrations. And the district court found, as if you turn to the next page, that's just a picture of the axle, so you can go on. The next slide, yeah. So what the district court found is that the claims were directed to laws of nature, Hooke's law and friction damping. The claims directed someone making this drive shaft to tune a liner to attenuate two different vibration modes. And he said that amounted to merely instructing one to apply Hooke's law to achieve the desired result of attenuating both vibration modes. How he got that, I don't know. Nowhere in the claim does it mention Hooke's law. Nowhere is there any formula in there. No math. It just says tune the liner, stick it in the middle of the shaft, and you have an invention. Now, you could argue, as did Judge, I forgot which judge it was. Flip the slide. Anyway, I'll get to the slide with it identifies the judge. But the way they say it's a complex way of applying Hooke's law to achieve simultaneous damping. And it is not recited in the claims so as to support the existence of an inventive concept. So there's kind of a backward way of looking at it. They look at the claim, the stuff is not there, it just says tune, and then they turn the claim down because it didn't have an inventive concept that showed you how to do the tuning. And so the court said that the additional steps consist of well understood routine conventional activity already engaged in by the scientific community. Next slide. So on appeal to the Federal Circuit, they applied the two-step test of Alice and Mayo, and whether the claims are directed to a law of nature, natural phenomena, or abstract idea, and if so, whether the claims embody some inventive concept. The question here is there, back up. So whether the claims contain an element or combination of elements that is sufficient to ensure that the patent in practice amounts to significantly more than a patent upon the ineligible concept itself. The court further stated that the requirement in Claim 1 to position the liner within the prop shaft does not add an inventive concept because of the district court's claim construction. Next slide. So, Judge Moore had a dissent, which I thought was right on. The problem with the claims is lack of enablement under Section 112. Regarding Section 101, the patentee maintains that liners had never before been used to reduce bending mode vibration. The patentee argued throughout that the position of the liner inside the shaft, an express claim element, is one of the characteristics to be controlled in attenuating bending mode vibration. The next slide. Okay, so let's see how much time. We only have a minute left, so I'm not going to do this. I'm going to leave this as an exercise for the interested student. And what essentially this slide does is says, if you take American Axle and apply the guidelines, what result do you get? And the end result you get is that it's patent eligible. I have signed on to an amicus brief, I think by the New York Intellectual Property Law Association, saying that we say this case is improperly decided. Because basically what the judge said is that they applied Hooke's law in order to design the liner. Applying a law of nature to a practical application is precisely what is patent eligible. So why the rest of the Federal Circuit got all bent out of shape on this and didn't come to the right conclusion, I don't know. But hopefully the Supremes will listen to our brief and we'll be in good shape. So I'll turn it over to Bob to conclude.
Well, I think we should do it together, Mel. I just think that this is a mess. We recognize that we've got big problems here. I'm telling my clients they need to keep their applications pending because we don't know where it's going to end up. Hopefully, and hope is not a plan, but hopefully they'll come to the right conclusion and make sure that they are advocating for, domestic growth and job creation by providing for strong 101 protection, but you don't know. So I would say file your applications, and when you file your applications, file applications with a detailed specification. And I go back to talk about a technological solution to a technological problem. Mel, take us home.
I couldn't agree more. There are legions of amicus briefs that are being filed in this case. So hopefully some clerk at the Federal Circuit, at the Supreme Court, will pick up one and read it and realize that a change needs to be made. And if they do, it could be a whole new day in terms of 101, but it could also be a situation in which they make a bad situation even worse. So fingers crossed.
Well, thank you both for this fantastic presentation. It certainly is as clear a description of 101 law as it currently stands as I've ever heard. So thank you very much. We do have one question in the box, and I realize we're a minute or two over, but I think we should nevertheless try to answer this question. This is from Watanabe-san. If patent applications are difficult under COVID-19, will the influence of COVID-19 as to patent prosecutions emerge after several years, sort of down the road?
Yeah, I will tell you, I've been, my last day in the office was March 16th of 2020, and I haven't been back since. And I deal with examiners all the time and get cases filed. My secretary lives in Long Island, which is, an hour away from where I am. And so she's filing things at all times of the day and night. And we've actually been able to handle and do a pretty good job of maintaining our patent prosecution practice. I call examiners, they call me back, have interviews. So I guess I don't subscribe to the basic premise that prosecution has become difficult. I've been writing applications sitting in my bedroom and getting it done.
Well said.
Great. Well, thank you to you both, Mel and Bob, and thank you to all of our speakers and panelists for the very informative presentations and discussions. I also want to thank all the attendees who contributed with comments and questions. Before we get to our closing remarks today, I would like to extend our thanks to Furuya-san and Nagano-san from JIPA, and also Mr. Yuichi Watanabe from AIPLA for their leadership and efforts in organizing this joint meeting. They did an absolute wonderful job in making this program happen. So thank you to all of their efforts.
And what a great platform. This was fantastic.
So to conclude the formal portion of today's program, I would like to invite each of the participating organizations to provide closing remarks. So first from JIPA.
Yeah, hi. I'm Go Shirozu from Gigaphoton. I'm a chairperson of the first International Affairs Committee of JIPA. It was a great pleasure to have a meeting with AIPLA. Today, we could get many informative comments on each topic. We will make the most of them to our research on the US patent law system. I hope we will have a meeting next year again. In addition, we are looking forward to having a chat with you in the networking session. Thank you.
Thank you very much, Shirozu-san. I would now like to invite Mr. Patrick Coyne, President-elect of AIPLA, to offer closing remarks.
Thank you, Jason. And thank you, everybody, for participating in these meetings. I mean, I know we did our meetings last year this way, and I thought that it worked out brilliantly. At least it's a way to connect and keep our contacts during this difficult period. But the substantive content tonight was great. You know, starting with means plus function, which is a huge train wreck and not getting any better, through AI-related inventions, which is an issue that's only going to grow in importance, to our update on U.S. litigation. And I just thought Mel and Bob did a great job explaining very concisely and very clearly an incredibly difficult problem that our Supreme Court and Federal Circuit have backed us into with no visible means of escape in sight. And all I can say is thank you to Director Iancu for having the what I consider mildly subversive approach of at least locking it in temporarily through federal regulations instead of just doing it by edict. So I hope everybody's enjoyed the program tonight, and thank you all for your participation. And we can now turn to our networking event.
Thank you, Patrick. So this concludes the formal portion of today's program. Recording will now end.